James Fifelski appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan.
Thank you. Your Honor, this is a first PCC. I am asking for an adjournment for discovery and investigation, so I can review discovery with my client. And if I could possibly address bond, I would appreciate it.
Right away, you can feel the defense trying to slow this case down before it gains momentum. A first probable cause conference usually sounds procedural and harmless on paper, but in real courtroom reality, this is where attorneys begin positioning themselves for the bigger fight ahead. Discovery, investigation, reviewing evidence with the client. Those are standard requests, but listen closely to the tone here. The defense is already trying to create breathing room because once prosecutors start laying out firearm allegations and pending charges, judges start paying very close attention to public safety and flight risk. And notice how calm this opening feels before the tension really kicks in. That's classic courtroom rhythm. It starts with paperwork language, scheduling requests, a 5 and procedural politeness. Then suddenly somebody mentions weapons, warrants, or prior convictions, and the entire atmosphere changes. This is also where viewers should pay attention to Judge Simpson's reactions. Judges often reveal their thinking long before they officially rule. A quick interruption, a short response, even sarcasm, those little moments matter. And trust me, this hearing is about to escalate fast once bond arguments hit the table.
Probable cause conference, May 29, 2025, 9 a.m. I need a screen sheet.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No.
I'm not sure.
They got up to driving without ops on the person.
Maybe a misdemeanor case.
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond. So,
but that case preceded this one, and then he picks up this one.
I don't know.
Actually, the other case that he has here is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant in Mississippi, but we can verify that there is a warrant for him out of Mississippi.
But we don't have the governor's warrant yet.
Correct.
Now the courtroom energy shifts dramatically because the conversation just moved from routine bond discussion into extradition territory. That is a major problem for any defendant asking for leniency. The defense tried to paint a picture of employment, family ties, 5 and stability, demolition work, children, a residence in Romulus, all the classic arguments attorneys use to argue someone is not a danger or flight risk. But prosecutors immediately counter with something much heavier. another weapons matter, and a Mississippi warrant hanging in the background. Oft 5, that changes the judge's calculus instantly. Even though the governor's warrant had not officially arrived yet, the mere existence of an extradition issue raises serious concerns. Courts start asking themselves, if released, will this defendant actually return? And once prior firearm history enters the record, the defense loses a lot of leverage. What makes this hearing especially tense is the timing. Prosecutors are arguing the older CCW case already existed before this new incident allegedly happened. In other words, the state is subtly telling the court, the defendant was already under scrutiny and still ended up back here again. That is devastating during bond arguments, and then comes the detail about gunfire near a deputy training a canine. Even though prosecutors clarify he wasn't charged with shooting at the deputy, the proximity alone sounds alarming in a courtroom setting.
And so there is a CCW, Mr. Sullivan has a pending CCW charge now, 8/27/2022. And then the facts of this case, I believe, fall. So that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, in 2012. And obviously this case involved possession of firearm and shooting it in the vicinity of a Washington County Sheriff's deputy who was training a canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training his dog, heard gunshots and saw a car drive off. And our allegation is that it was Mr. Sullivan who was shooting, basically testing out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the bond. Frankly, the $10,000 bond is low.
Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied. Most of the bond reduction is denied. Bond will continue. Thank you.
Who is approaching? Mr. Artuso, state your name for the record, please.
Rick Artuso. Thank you.
Your Honor, I do have a green sheet. We're asking for an adjournment. We're currently in negotiations with the people. I would like to also address bond, please.
Matter will be adjourned May 29, 2025, 9 a.m. Yes.
Your Honor, in regards to bond, we're asking Mr. Artuso, Mr. Burgess is on one of his matters. I apologize.
Okay. Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Rick Artuso, as the other matter.
All right.
So, Your Honor, in my matter, Mr. Artuso has a $1,000 10% bond that was set. He does have a cash or surety bond in Mr. Burgess's matter. Mr. Artuso, it seems as if he went into bench warrant status on Mr. Burgess's matter because he failed to appear to court. He did indicate that he came to court on that date, but he was under the impression his court date was set for 2:00. When he did come, he stated he was here until the building closed and he left. Unfortunately, at that time, our office was not on his case, so he didn't call us. I'm unaware of his communications or if he was able to communicate with Mr. Burgess. So there was no opportunity to have a bench warrant recall.
So how do you come back into custody?
You said you were just in the car that was pulled over.
Yes, I got pulled over.
So he was arrested on the bench warrant, Your Honor. There are no new charges.
So why didn't he come back to court?
I did ask him that as well.
Okay, and what was the answer?
He did not have an explanation, Your Honor.
Okay.
It was
Go ahead. I'm listening.
He did not have an explanation as to why he did not come back to the court, why he did not, contact the court to let them know that he tried to come. I did explain to him in the future if he's got any issues with his court dates that the clerk's office is right there at the front, that all he needs to do is speak with them and they'll advise him properly.
This hearing suddenly becomes incredibly human because now the court is dealing with something judges see all the time. Defendants claiming confusion. I-5 about court dates after failing to appear. The defense attorney is trying hard to present this as a misunderstanding instead of intentional avoidance. He says the defendant thought court was at 2:00, waited around the building, and eventually left. On paper, that explanation sounds possible, but courts usually expect one critical thing afterward: communication. That's the issue Judge Simpson keeps circling back to. I-5, why didn't he contact the court afterward? Why didn't he fix the problem voluntarily? Why did police have to physically pick him up later during a traffic stop? Those questions matter because judges treat reliability very seriously. And now the defense introduces another strategic angle, restitution. They're essentially arguing that keeping the defendant in custody actually hurts the possibility of resolving the case financially. That's a smart move because it reframes release as beneficial to the court process itself. Add in the offer of GPS tether supervision, and you can see the attorney trying every reasonable middle ground option available. But the courtroom tone tells you Judge Simpson is still deeply skeptical. Once a defendant misses court, rebuilding credibility becomes extremely difficult.
The issue that we're having is, in our case, the resolution that we're seeking to reach would require that he pay some restitution up front. Unfortunately, with him being in custody, Judge, he will not be able to do that. He is hopeful that the court would consider giving him a PR bond. I understand if a GPS tether is necessary to ensure his return to court. He has very minimal criminal history, to my understanding as well, but I'd like to see if he could get out so he could raise some money and pay off this restitution so we could get a resolution.
Sponsoring people.
I would leave it up to your discussion.
If he doesn't appear, doesn't come back, it's got to be picked up. It's going to sit until we can get it resolved. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor. What do you need to say?
I was gonna ask you, Your Honor. Worst comes worst, I know I could, it's Thursday. I'm scheduled to be married on Sunday. I could come in Monday and I could pay restitution, whatever it takes to pay.
Scheduled to be what?
Married this Sunday.
That is true, Your Honor. He did inform us of that. I don't know if his fiance and his mother are here, but prior to his being picked up, I think he was scheduled to be getting married this Sunday.
I'm not going to use that as a basis to fund. I mean, the problem is that you should have come back down to the court. If you waited here all day, you should have come to the court at some point, but we had to pick you up, bring you in. I'm not doing that again. Thank you.
Thank you, Your Honor.
Got a problem. All right. We pass it. Thank you. Yes.
What an unbelievable emotional turn this became. Moments earlier, the defendant was explaining that he was supposed to get married on Sunday, Al 5 hoping that major life event might persuade the court to show mercy. And honestly, for a split second, you could feel the emotional weight land in the courtroom. Weddings, family pressure, future plans. Those details humanize defendants in ways legal arguments sometimes cannot. But Judge Simpson immediately pulled the hearing back to accountability. The judge's position was crystal clear. If someone waits at court all day and believes there's confusion, they still have a responsibility to walk into the clerk's office and resolve it. Courts expect initiative. They expect follow-through. And the judge made it very obvious he was not willing to repeat the cycle of missed appearances and bench warrants. This is one of those hearings where emotion collides directly with procedure. The defendant wanted compassion. The judge wanted reliability. And in courtroom settings, reliability usually wins. Also notice how quickly the courtroom moves afterward. One emotionally charged exchange ends, and within seconds, another case begins. That's the reality of criminal dockets, deeply personal moments happening on an assembly line of legal consequences. Do you think the upcoming wedding should have influenced the judge's decision, or was the court right to focus strictly on accountability?
They got to cover your butt. You don't want to see it.
Okay.
Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's
true.
correction stuff.
No, oh, yes, they rescheduled my appointment for Monday at 9:30 with the brown guy for the outpatient program.
Yeah.
Yes, because I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was going to come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave
You're
my system.
still using.
No, I'm not.
No, because you want, okay, I'm going to tell you what. If you're telling me you're not, I'm going to take you back. I'll call over, get levels, and then we'll see exactly what's happening.
So I got
You want me to do that?
so I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
This exchange is brutal because the defendant walked directly into a credibility trap. Judge Simpson kept giving him opportunities to clarify his statements, but every answer created another contradiction. First, the defendant says he probably would not test clean, then he claims he is no longer using. Then he says cocaine may still be leaving his system. The judge immediately notices the inconsistency and starts drilling down. And this is where experienced judges become extremely difficult to outmaneuver. Judge Simpson isn't just listening to words, he's testing logic. If the defendant truly stopped using, then the levels should trend downward naturally. But the judge clearly suspects something else may be happening, which is why he orders additional verification through community corrections. The sarcastic super-duper cocaine line tells you the judge no longer fully believes the explanation being presented. That sarcasm may sound humorous to viewers, but in courtroom terms, it signals serious doubt. Once a judge believes someone is being dishonest in open court, future requests become much harder to win.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm going to do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. Okay. About to call her client back up. Court does recall the case, People versus Hill.
I think there were nothing for the people.
Well,
Yes, Your Honor, we did receive the results in this matter, and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're going to have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, 2 weeks on.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked.
And Mr. Hill?
And there it is, the moment everything fully unravels. After the court reviewed the actual testing levels, the numbers told a completely different story than the explanation the defendant initially tried to provide. The cocaine levels did not continue dropping as expected. Instead, they spiked dramatically. Once that information entered the record, the defense position became nearly impossible to sustain. To the attorney's credit, there was still an attempt to redirect the situation toward treatment and drug court screening, which is often one of the last realistic avenues available when compliance problems begin stacking up. Drug court can sometimes offer structure, 5. Supervision and rehabilitation opportunities for defendants struggling with substance abuse issues. But before any program works, the court has to believe the defendant is being truthful. That credibility issue became the central problem in this hearing. Across this entire session, Judge Simpson consistently focused on accountability, whether it involved firearm allegations, missed court appearances, N-5 restitution obligations, or failed drug compliance. The rulings may have sounded harsh at times, but the judge repeatedly emphasized one theme. If the court cannot trust a defendant to follow instructions, bond reductions and leniency become very difficult to justify. And that final bond revocation sends the clearest message possible. The court believed continued release conditions were no longer working. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.